off at the bottom of your Zoom window. And then we'll also have the transcription of the webinar available afterwards if you would like to see it. You can just send me an email and I'll put that in the chat in just a minute. And then lastly, as we are hosting in the webinar format, everyone is muted, so you can place any questions or comment in the chat or Q&A area. And then if they've not been addressed by the end of the presentation, we will go through those at the end of the presentation and answer them before we leave today or connect with you afterwards. So today we are excited to host some great folks from the U.S. Copyright Office. And Jessica, I will hand it over to you to kick things off.
Great. Thank you so much, Caroline, and welcome everyone. Thank you to KYIPA for having the Copyright Office here today. We're really excited to talk to you all about the offices that we provide at the United States Copyright and Office, as well as just copyright basics in general, including registration. So I'm going to kick us off with a brief introduction, like I said, to the Copyright Office, where we are, what we do. I'm going to share some of the basics of copyright with you all. And then I'll leave about 15 minutes for Q&A at the end. So please, as Caroline mentioned, submit those and we'll try to address them at the end or perhaps throughout the presentation as well, but we'll definitely get to them. So without further ado, jumping into who the Copyright Office is, we were founded in 1870 in the Library of Congress. We are a federal government agency in Washington, D.C. We are part of the legislative branch of government, which might be a little different if you're familiar with the United States Patent and Trademark Office. That is a separate executive agency responsible for patents and trademarks, and they are within the Department of Commerce. So again, we're in the Library of Congress and part of the legislative branch of government, which is a unique part of our history. As for what we do, and when we talk about the Copyright Office and what we do when it comes to administering the Copyright Act, that's a pretty broad statement, and it does entail a number of different roles and responsibilities that each, division within the office kind of covers. So in general, we create and implement regulations. We also maintain copyright records, administer statutory licenses. We provide legislative support and advise Congress by responding to member and staff questions. We participate in hearings and provide trainings to Congress as needed. And we also do the same on an international level in the international copyright community and the international intellectual property community. That includes collaboration with executive branch agencies such as the USPTO. And then lastly, in a big way, kind of what we're doing here, we provide information to the public on copyright, including through presentations like this. So the United States Copyright Office's main mission is to promote creativity and free expression. And I wanted to share with you all what that means in the context of our 4-year strategic plan, which you see here on the slide. So one of our main priorities this year is to broaden participation in the copyright system. That is, of course, important to the public's understanding of copyright, especially those individuals, maybe small entities, large entities who are part of historically underserved communities. On this slide, what I'm talking about specifically is what we call Copyright for All. And that is part of our 4-year strategic plan that was implemented in January of 2022. And it's a plan titled Fostering Creativity and Enriching Culture. As you can imagine, broadening the system, making it as understandable to as many people in the public as possible is what we mean by Copyright for All. The other 3 goals you see listed here include continuous development, which is our commitment to, updating and improving our services, both from a technological standpoint, as well as just being flexible and being available to you as the public. The goal of impartial expertise means continuing to provide expert advice on copyright law and policy to Congress. I already mentioned Congress, but we also assist and advise the courts, as well as other agencies, both domestically and internationally. And then lastly, here you'll see the goal of enhanced use of data. So that means that we're enhancing the use of data as a decision-making and policy-making statistic or enhancer, especially as it's related to performance measurement. And we're making that data available to stakeholders who can kind of help us advance copyright knowledge generally in society. So on the note of data and enhanced use of data, we have actually learned from studying our copyright registration records that unfortunately women are not participating in the copyright system at the same level that men are. We don't know why that is, but our Women in Copyright initiative, which is something that we're really excited about starting, and a link to the Women in Copyright initiative was just put in the chat. What that is going to do is we look to take 2 steps specifically to address the gender gap when it comes to copyright registration. So last year, you see this report that we issued in 2022, and we are sharing the data set from that report with other researchers to help us further unpack the facts, what it means, and the trends that we're seeing when it comes to women's participation in copyright. And then secondly, we're ramping up our outreach to women and girls specifically to increase their awareness of copyright and of the IP system. So that was just kind of something I wanted to talk to you all about. This is just one example of the many sorts of policy studies that we have. One especially that focuses on data right now, and we're really excited to share that with you. But in the meantime, I wanted to move on to copyright basics and why I'm here. So what is copyright? It starts, I think, importantly, to talk about copyright in its entirety when it comes to considering other types of intellectual property. And it's important to distinguish copyright from the other IP that you see here on the tool. And I apologize, intellectual property is often shorthanded as IP. So trademarks are a tool that prevent a company from adopting a name, maybe a tagline or a product configuration that might be confusingly similar to that used by a competitor. So trademarks in that way help consumers identify the source of what they're buying or using. Patents, on the other hand, are going to protect your inventions and discoveries. So we're talking about things like ideas, processes, methods, concepts, machines, and devices. And not listed here before I jump into copyright is actually trade secrets. That's we're talking about business insider knowledge to a specific business that is also protected by a separate sector of IP. As for the last bubble here, copyright, again, that's why we're here. And copyright protects the expression of an idea. So that is the exact words or the form chosen to convey an idea. And just to further distinguish everything on this slide, the United States Patent and Trademark Office administers the top 2 here, patent and trademark laws, and then the United States Copyright Office administers our nation's copyright law. So copyright law is currently found in Title 17 of the United States Code, and what it protects is original works of authorship fixed in a tangible medium of expression. So what that means is that we must first have a work of authorship, and then that work must be original and it must be fixed. Now, I know that sounds like a lot of fancy phrasing, but these are what's known as the 3 kind of basic elements of copyright. And I'm going to discuss each of these today in a little bit more practical manner, especially if you're interested in registering your works with the office. Knowing this information might help you as an entrepreneur, a business owner, just an individual, as you keep in mind, what our office looks for and prepare your application materials accordingly. So I said this word a couple times in the last slide, works. Well, what is a work? Section 102A of the copyright law provides a list of categories of works that constitute copyrightable subject matter. So this list includes types of works that can be protected by copyright. You're talking about literary works, including, books, poems, newspapers, musical works such as songs, dramatic works such as plays, pantomimes, and choreographic works. Pictorial, graphic, and sculptural works is a very broad category. As you can kind of see by the parenthetical here, we're talking about paintings, drawings, but also sculptures. And then a separate category is motion pictures and other audiovisual works. So think about your TV shows, your films, as well as even video games, for example. Sound recordings, which are separate from musical works, are going to be the capturing of the sounds in a musical work. So for example, something on a CD, or for example, another sound recording could be a podcast. And then lastly, we have the category of architectural works. And architectural works does include both the blueprints as well as certain buildings. As you can see again, though, in these parentheticals, the categories here are very broad. They do encompass, many different types of works. Some are lesser known. For example, literary works do include computer programs. You can register your source code for a computer program, and that's considered a literary work. As well as, something like fabric, maybe wallpaper designs. Those are both pictorial, graphic, and sculptural works, for example. So that's just a little bit on the categories of works that are protected by copyright. As for what's not protected, that falls to Section 102B of the copyright law. So this gives us some examples of material that does not constitute copyrightable subject matter. So again, we're talking about things like ideas, procedures, systems, processes, concepts, principles. That could include things like algorithms, scientific formulas, discoveries. Some of that may be protected by patent. If you're familiar with patent law, of course, separate discussion. But again, this is material not protected by copyright. So now that I've kind of gone over what qualifies as a work, let's look at what it means to be original. So you'll remember from earlier on, I kind of talked about the elements of copyright. We talked about original works of authorship, and originality has a very specific meaning in copyright law that's a little different than what we would think of it just as it's in its colloquial sense. So a more practical breakdown of originality is that we're looking for two elements within originality. The first is independent creation, and then the second is sufficient creativity. So independent creation just simply means that the work must be independently authored by you, independently created by you. And what we mean by that is that the work must originate from you, it must be yours, and it must not be copied from another work or another person. I will say in theory, two works, though, could be the same or similar and each be subject to copyright protection so long as the similarities are, by chance and not a result of copying. An example here is if, I were to take a photograph of the Washington Monument and so were Caroline, that would be an example of we each have independently created that photograph, but they may be very similar depending on if we took that photograph from the same angle with the same lighting, etc. So I just want to clarify here that independent creation is a little different than plagiarism, and people often tie plagiarism and copyright together. I mention this here because a lot of times the office gets asked if we search our records to make sure that something that they're submitting is different from a work that's already been registered, or if it's identical to a work that's been registered. The simple answer here is that's not what the office does. We do not search our records when you submit something to us. Instead, as a general rule, we kind of accept your assertion that the work was independently created by the author named on the application, and that's the case unless something is known to the office that contradicts that or makes that statement implausible. But generally, that's why we have people certify an application, and that's just how plagiarism is a little different than what we're talking about when we talk about copyright infringement, and I will get into that in just a minute. As for the other requirement that I mentioned for originality, that was sufficient creativity, and that requires that the work contains at least a small amount of creative expression. But that small amount must be more than trivial. So this information comes to us from a very famous Supreme Court case called Feist. And in that case, they were talking about how facts are not copyrightable because facts and data are essentially, they don't rise above that law of trivial matters. Examples of other works that don't meet the requirement for that creativity include, words and short phrases. We don't want people to have a monopoly on names, titles, slogans. You can register your slogan with the PTO, but not with the Copyright Office for that very reason. And then the same thing on, maybe more of an artistic standpoint when it comes to familiar symbols like hearts, smiley faces, rainbows, simple geometric shapes like squares, ovals, and circles. We don't want people having a monopoly on that either. Lastly, just a few other things that are good for you to know are not copyrightable. Typographic ornamentation, so typeface, font, lettering, and then mere variations of coloring are also not copyrightable. So to tie it all together here, really what you want to take away when it comes to the creativity requirement is that it does have to be more than trivial, but it doesn't need to be, particularly innovative or presented to us in a particularly surprising way. At the same time, though, it does have to be more than something we'd call routine or typical or maybe even inevitable. And then not mentioned on this slide, I just wanted to talk briefly about one more requirement for copyright, which is human authorship. So human authorship is currently part of a larger topic that the office is delving into related to copyright and artificial intelligence, or AI. But the office will only register material created by a human, for example, not a machine and not an animal. So other than originality, which we talked about as one of the elements of copyright, fixation is another one that we can dive into here. So most works are fixed by their very nature. This phrasing might seem kind of confusing for you, but the office rarely encounters works that won't satisfy the fixation requirement. Basically, the work must be written, recorded, or otherwise captured in a copy or a phonorecord. A phonorecord, for example, is like a CD or a digital MP3. And it must be sufficiently permanent or stable to be perceived, reproduced, or otherwise communicated for more than a transitory duration. Really, the key takeaway that I want you all to take for fixation is that copyright protection begins the moment the work is fixed. It does not, contrary to popular opinion, it does not start when it's registered with our office. So copyright is automatic. It begins the moment that you create something, such as putting down your poem that's in your head onto paper or into a Word document. Another thing to just remember about fixation, and it's kind of something that I think is commonly confused or misunderstood, is that copyright is separate from ownership in a physical item. So copyright in a work is, the intellectual property, and that's why we call it intellectual property. And then we have real property as well, where the thing that you possess is the thing that you own, but you may not necessarily own the copyright. Key takeaway there: the owner of a work still maintains the copyright in it, even if they have sold or given away copies of it or allowed others to use those copies. So that's something really important as you use others' works. Just remember copyright. And I actually have a full slide to tell you all about how to responsibly use and responsibly consider copyright when you're creating things. Before that, though, let's just talk really quickly about how long copyright lasts. Once you have a copyrighted work, it's important to think about how long that protection lasts. And the copyright clause in our Constitution, I had it up on a previous slide, but it gives Congress the power to enact copyright laws. And the language from that exact clause says that its purpose is to promote the progress of science and the useful arts by securing exclusive rights to the author's writings for just limited times. So basically what this clause is telling us is that it will be unconstitutional for copyright to last forever. That being said, the current term for copyright protection is for the life of the author plus an additional 70 years. That's just in the case of like a single author or a joint author, for example. In the case of a work made for hire, which I'll get into in just a minute, as well as an anonymous or pseudonymous works, the term is a little longer. That's going to be 95 years from first publication, the date that it was first published, or 120 years from the date that it was created, whichever is shorter. So I think these next few slides will be really important for you all to keep in mind, as if you're a startup owner, maybe even entrepreneur, who is a copyright owner? So initially, an author of a work is going to be the initial owner. In most cases, the author, that phrase, is the person who created the work. Again, what we talked about is that person whose the work is originating from. So they are the initial owner. The author is the initial owner. In certain situations, though, the author may not be the person who actually created the work. And this comes into play with what's known as works made for hire. You might have heard of this doctrine. You might have signed paperwork in your employment that talks about work made for hire. But essentially, there are two parts of definition of a work made for hire in copyright law. The first part of the definition talks about a work that's been created by an employee in the scope of their employment. Or the second part of the definition covers a commissioned work that fits within categories within the law that the parties have entered into a signed written agreement about. So that written agreement will state that the work is explicitly a work made for hire. And in the case of a work made for hire, the author is going to be the employer or the commissioning party, as opposed to the person who actually created the work. So in these cases, again, the employer or the commissioning party would also be the owner of the work. Goes back to that same concept that initial author equals initial owner. As for the last bullet point here, a third path to ownership is through what we call written agreements, just legal instruments, usually contracts, for example, where copyright can be transferred in writing, from person to business, and so on. But it must absolutely be in writing in order for it to be considered a legal transfer of ownership. So there are other types of transfers that I don't want to dive into too deep today. For example, state community property laws, partnership agreements, but just know that, that's a pathway to copyright ownership as well, is through contracts. So now that you know who an owner is, let's just talk really briefly about what rights an owner has. So you hear the word copyright and you might think just a single right, it's the right to prohibit people from copying. But copyright is actually more than one right. A lot of times, people think, again, it's just this first right listed here, which is the right to reproduce or to make copies of your work. But as you can see, that's one of 6 exclusive rights. So we call them the exclusive rights of copyright. And they are the rights that an owner of copyright has when it comes to specific types of work. So for all works, an owner has the exclusive right to reproduce or make copies of their work. They also have the exclusive right to prepare derivative works based upon the copyrighted work. You might have heard of derivative works, but for examples include, like a remix of a song, maybe a translation of a book from English to French. Adaptations of a movie into, or I'm sorry, a novel into a movie. All those are examples of what we call a derivative work, basically a new work on which a former work is based. Public distribution is essentially publication. So that's when by rental, lease, sale, lending, you're giving your work to the public. The owner of a copyright has that exclusive right to publicly distribute their work. And then the last 3 here come into play, I would say primarily with, literary, musical, dramatic works, maybe even pantomimes and motion pictures. You can perform your work publicly, you can display your work publicly. And then for sound recordings, especially, there's a specific right, which is public performance through digital audio transmission. So those are the exclusive rights of copyright. The biggest thing to keep in mind here, I mentioned I'd talk about copyright infringement. Copyright infringement is when an owner has not authorized or given permission to someone to perform any of these exclusive rights. So it's not just copying. When we talk about copyright infringement, it could be performing publicly or distributing publicly as well. So even if you're not an owner, we want to we want to let you know and have you feel rest assured that there are still lots of ways to responsibly use creative works that are out there while respecting copyright. I would say the primary way is what we just talked about in terms of asking permission. So permission is key, and you'll ask permission from a copyright owner. In that case, you don't actually have to have the ownership transferred to you, via a contract, for example. You can just ask for a license to use the work. That could come into play if you're writing a book and you want some illustrations that are created by someone else. You can ask for a license to use those illustrations. Another way to responsibly use copyright includes just knowing that there are limitations to the exclusive rights that I just talked about. So the biggest limitation that I think most everyone has heard of is fair use. It is the most popular, but it does require a pretty significant analysis and balancing of 4 factors. This was most recently done in a Supreme Court case related to a photograph of Prince. You might have heard about it. It was just, the opinion was released in May, but essentially the court will do that balancing and the analysis of the 4 factors. The 4 factors being the purpose and character of the work, the nature of the copyrighted work, the amount and substantiality of its use, and then the effect on the market value of the work. So again, I wouldn't say that we at the Copyright Office recommend relying heavily on fair use because it is a case-by-case basis. There is no bright line rule when it comes to fair use. It's something you would want to consult an attorney about, for example, and it's something that you would want to feel assured that you can use as a way to responsibly use copyright. Another sort of limitation that is similar to fair use is first sale. So the first sale doctrine just says that the owner of a particular copy or phonorecord that's been lawfully made is entitled to, sell or otherwise dispose of the possession of that copy without the authority of the copyright owner. Again, part of the copyright law, a provision that an attorney could certainly help guide you through understanding. And then thirdly, here we have on the left side statutory licenses. These are available for a statutory fee. You also have to comply with certain notice requirements. Again, very specific language in the law, but definitely an exception to the general exclusive rights. And then lastly, on the right side, I'm going to talk about the public domain. It's very popular. The public domain is not a place, though it is a concept. It is what we refer to as where expired works, maybe works not protected by copyright or uncopyrightable subject matter, where they reside essentially, but it's not a place. The public domain includes, though, images, for example, creative works that are all available and free for you to use without consultation from an attorney, and a great way to responsibly use copyright too. So that was really the gist of copyright basics. I saw a few comments come through in the chat just about the case that I mentioned, and thank you to our law clerk, Sally, for putting in a few helpful links in the chat. I'm going to move on to registration next. I think this is a topic that is very interesting for this group and something that our office focuses on quite heavily. So copyright registration is the process by which you submit your work to our office and it is registered. But remember that registration is not required for you to have copyright because copyright is automatic. It exists, the moment that you create your work. As mentioned before, when I talked about fixation, copyright is automatic, and so therefore copyright registration is not required. And even though it's not required in order to secure or obtain a copyright, we do strongly recommend it. We strongly encourage it because it provides several important benefits. And I'm going to cover the benefits in the next slide. But basically what I want you to know about copyright registration is that registration only needs to occur once for each work. You do not need to renew your registration. You don't need to re-register it at a later date. And you should know that the Copyright Office is the sole administrator of the registration system in the United States. What that means practically, for you as a future applicant is that in order to pursue litigation, if you were to want to sue someone for copyright infringement in our federal court system, to enforce those exclusive rights that we talked about, you will need a registration decision from the Copyright Office. So that is a huge benefit, and it's the first one on this slide, because what it means essentially is that registration is a prerequisite to filing a copyright infringement lawsuit for a United States work. What this means is if a work is infringed, that work must either be registered with our office or the office must have refused registration in order for you to file with a federal court. On the same note, when it comes to the federal court system, registration may provide access to statutory damages and attorney's fees while you're pursuing litigation. Those things, statutory damages and attorney's fees, are available to you if you timely register. And what timely registration means is that the work must be registered before the infringement began or within 3 months after the work was first published, if you chose to publish your work. Similarly, timely registration is important if you were to try and essentially have the facts on our certificate, serve as prima facie evidence in court. Prima facie meaning, on its face, the court takes the word of the Copyright Office and the facts that are on our certificate. Again, timely registration here means if a work is registered before or within 5 years after the work is first published, then that will create that prima facie evidence in court that creates what we call a rebuttable presumption that the work has a valid copyright. Registration can also provide information to those seeking to license or use a work by providing, the name and the address of the person, maybe the organization or the lawyer or the agent that, a potential user should contact to obtain permission. So we talked about permission being one of the big ways that you can responsibly use copyright, and registering with our office means that you put that information, who to contact to get permission, right on the public record, right available for everyone. And then lastly here, registration in the world of creating a public record, that means that it includes key facts about the work being registered, not just who to contact for permission, but for example, who the author is, who the owner is, maybe a transfer has occurred by a contract, as well as information maybe about the title of the work, maybe the year the work was created, and if it's been published, where it was published, when it was first published. Those are all very important facts that the public should know about your claim to copyright. So those are the benefits of copyright. And as for what's required to register a work, what you will need is a completed application package, which consists of an application form. You can submit a paper form, you can submit an online form. We do strongly encourage online forms and online filing simply because it's faster. You can check in on the status of your work, and in most cases, it's going to be cheaper as well. And that is actually, on the note of a fee, the third component of a full application package. It's going to be your filing fee. Your filing fee will depend on the type of application that you submit. For example, there are different types of applications you can use to register one work. There are different types of applications you can use to register more than one work. For example, a group of unpublished works, a group of unpublished photographs, a group of published photographs. There are lots of options for you to explore on our website when it comes to application types. But this in general, the slide just kind of summarizes for you what you would need, and that's the completed signed application, deposit, and the fee. And I'm sorry, I skipped over the deposit, but the deposit is what we call the copy of the work. So if you've written a book, we just want a copy of that book that you've written, and that's what we call the deposit. So this slide summarizes basically the critical elements that the Copyright Office will look for when they are examining your application and your submitted work, that completed application package that I talked about. So number one, they're going to ask, is there human authorship? Is there clear human authorship here? Is there copyrightable subject matter? Does it fall under one of those categories of literary works, pictorial, graphic, sculptural, musical works, etc.? And then, is the work original? So originality, again, we're going to look for independent creation as well as sufficient creativity. Does it rise above that bar of our basic facts, basic words, basic shapes into something sufficiently creative? So the examination process at the office involves, checking all of that, as well as checking legal and formal requirements, making sure those have been met. So a few examples include, completed application. Could mean different things depending on the type of work that you're registering, the number of works that you want to register. That group option for unpublished works that I mentioned, for example, has eligibility requirements. You cannot, for example, submit a collection of poems and submit 10 different collections of poems. You could submit 10 different independent poems, and that would be okay. But for example, that's something that the registration program would look into when it comes to an eligibility requirement. On the note of applications, I'll just throw it out there that our cheapest application option in general right now, if you want to register one work by one author, and it is not a work made for hire, that application option right now is $35. So very affordable option for you to get your works registered. And then lastly, on the note of examination, I just wanted to mention that you might hear from the office during your pending application review. It doesn't necessarily mean that there's something wrong with your submission. More often than not, it's a specialist that's reaching out to you to help you complete the record more accurately so that we create an accurate, efficient public record. And so it is the registration specialist's duty to kind of communicate with you as an applicant to get any sort of issue like that resolved. That's actually a great segue to information generally from the office. And I know I just went through a lot of information, and at this point, I thought I'd just loop back to what I was saying earlier, about our office's services, what we provide, and how we can help you. So first, our public information office, they answer phone calls, email questions from you all. So if you've got anything that you're wondering about specific to your situation or in general about copyright law, you may be able to reach out to us via email or phone. We have dedicated staff members as well who can help guide you through an application. So I just talked about there being tons of application options. Our dedicated staff can actually help you determine which may be the best application option for you to submit, and then they can provide a walkthrough of that application. And that's essentially when a staff member will assist you by navigating the electronic registration system rather than the paper. They'll explain the application screens and the information that's required and clarify that for you and help you achieve what you want to, hopefully in a 30-minute walkthrough for one type of application. So there is a form on our website where you can submit a request to do a walkthrough, and they will schedule an appointment with you. Secondly, though, our outreach and education section has created a number of helpful, important online resources. Our law clerk, Sally, has been dropping a lot of those into the chat already. But for example, our circulars, they are great narrative forms, PDF forms that you can just read through on a certain concept. For example, works made for hire, copyright notice, and then deposit requirements, for example, to the Copyright Office as well as the Library of Congress. So circulars are just one example of our online resources. We also have frequently asked questions, so our FAQs on our website as well. And then we have a great video series on YouTube where you can learn more about concepts like fair use, the public domain. It's what we call our Learning Engine series. And so it's a great way to learn more about various concepts in copyright as well if you're a more visual learner. So lastly, I am just going to end here with a brief discussion of a fairly recent development at the Copyright Office. So just last June 2022, our Copyright Claims Board, that's known as the CCB, they opened their doors to the public. So in December, for background, in December of 2020, Congress passed what's known as the CASE Act, and that stands for Copyright Alternative in Small Claims Enforcement. And the CASE Act directed the Copyright Office to establish the CCB. But in general, what you should know is that the CCB is a 3-member tribunal within the Copyright Office that provides an efficient and user-friendly option to resolve certain copyright disputes, particularly those that involve up to $30,000 in damages, hence the name small claims in the CASE Act. So this is a voluntary alternative to federal court. Prior to the existence of the CCB, the only way you could sue someone for copyright infringement was in federal court. Now you have another alternative. It is more streamlined, it is more affordable, and you have a way to enforce your copyright and the exclusive rights right at your fingertips. So we love talking about the CCB, especially as it relates to our goal of copyright for all, because this is a forum that absolutely increases, your access to justice should you need it when it comes to copyright infringement. So lastly, before we go to Q&A, I am just going to encourage you all to follow us on social media. We are very active on Twitter. We have, as I mentioned, that YouTube channel, so the link is right here on the screen. And then we also have our Newsnet. So our Newsnet is essentially a digital newsletter. It's a service that you can sign up for at copyright.gov. You'll receive news and updates to your emails on various initiatives. For example, that Women in Copyright initiative, the Copyright and AI initiative that's ongoing. So please feel free to subscribe to options there. But Caroline, I am done with my presentation, and I think you were going to help facilitate Q&A if we've gotten any from the audience. I haven't seen any come through in the chat, although Sally did just say that she will leave a question for me, so I can get to that one first if you would like.
Yeah, so I think Sally's been answering most of them in the chat. The one she said she was going to leave for you is, if someone copyrights a book they wrote, will it go into the Library of Congress?
That's a great question. So, I mean, the Copyright Office does act as a conduit for the library's collection via those deposits that I talked about, which is your submission to the Copyright Office for the registration process. That being said, not every book goes to the Library of Congress, and those guidelines are set out by the Library of Congress. So, Sally, there might be a helpful circular. I think it might be circular either 6 or like 6E, 6A that talks about deposits and what goes to the Library of Congress and the what we call the best edition of a work, where for example the library will want a hardcover of your novel rather than a paperback. So really the library has those guidelines out there for you, but we can get some helpful resources for, is it Amy? Yeah, Amy that asked that question.
Thank you. I'm not seeing any more questions, but I did have one. Could you
Sure.
all share the link to the application walkthrough to everyone?
The
The
form, yes.
request, yeah, I think
Yeah,
that would be a great resource for everyone that's on today.
sure. We can give it a few minutes. I'll
Okay.
just also, I forgot to mention one thing on the CCB, which is that you do not need an attorney to, work through or navigate the CCB process. So it is intended to be something or a forum where you can represent yourself. And it's not necessarily like court, it's not like litigation where you would be arguing perspectives. It's certainly more of submitting paperwork to the CCB and navigating their process. But in general, they have a wonderful handbook available on their website, which is separate than copyright.gov. I should mention that too. So the CCB has their website at ccb.gov. And on ccb.gov, there is a very helpful 15-chapter handbook where you can kind of read through what's going to be expected of you at each stage of the process, should you choose to use the CCB. And then I see that Sally just put in our registration portal. So thank you,
Yeah.
Sally.
Okay, we have a couple more coming in. If you have one collection work that has both literary and media parts, so videos, which category do you register the work under?
Yeah, also a great question. And generally our answer is which type of authorship is most predominant. So I'm guessing if there's something like a website that will have, or like a blog that will have the textual written material, maybe even photographs inserted, videos inserted, that's an example of something where you'd still submit that as a literary work as website content. But yeah, great question. It's going to be mostly the predominant material that you see in that work.
And then if I use ChatGPT to generate a document, will I have a copyright issue?
Yeah, I can cover copyright and AI generally. So we can't necessarily provide a distinct answer on that question, which I think is going to be case dependent. What I will say when it comes to using AI in your copyright and your creative process is just know that if a work is solely created by AI and you try to submit that to the office, we will absolutely deny that. However, if your work includes portions that have been created by AI, we have recently released guidance around how to register your work. And yes, Sally can put this in the chat. It's a website initiative that we have related to copyright and AI right now, and that guidance is on that website. But I can just briefly give you a summary of what it is. The registration guidance says that you must disclose to the office the content that has been created by AI or by anybody else. That's always been the case. So even if you were collaborating with a non-machine, with another human, you would always have to disclose that and say, this portion was written by Sally, this portion was written by Jessica, and the book was co-written by these two individuals. It could be the case that you say on the application, this portion was written by ChatGPT, this portion was written by me, but that information has to be disclosed to the office. So it's not impossible. And then the key is that you need to make sure it's more than what we call de minimis authorship. And de minimis just means that it's more than a significant amount of material that must have been created by the human as opposed to the machine. I see a question in the chat about, do licenses need to be in writing? Yes, so most transfers of copyright ownership, which is separate than a license, need to be in writing. Licenses, non-exclusive as well as exclusive, also just acting as a literary, or I'm sorry, as a legal license there, also need to be in writing.
Okay. I think we have a follow-up on the ChatGPT. Will I have liability for copyright parts that ChatGPT uses?
Yeah, so the liability question is one I think the office continues to explore, especially as companies explore their own liability and risks. So what I will say is that the Copyright Office, as employees, we cannot offer legal guidance or advice or opinions. So the best bet would be to contact a copyright attorney and to work with someone that can give you that legal advice and opinion. For lawyers, you can obviously look through your local or state bar association directory for lawyers that might be willing to help you or assist you in matters of copyright. And then there are also the volunteer lawyers that, volunteer lawyers for the arts, volunteer lawyers and accountants for the arts that also work with individuals on copyright issues like this. And then we also have legal services. So there are legal services in each state that might be able to assist you there. But because this is so case by case, the office cannot provide, a direct answer on that.
Thanks. Okay. I think that's all the questions we have for now. We can stick on for a couple more minutes, but
Absolutely.
other than that, I think great presentation. Thank you all so much for all this great information on all the process and resources available. And then thanks to everyone. We are getting one more, but yeah, thanks for everyone hopping on. And then this last one coming in: are copyright infringement remedies typically damages or injunctions or both?
Yeah, I don't know if I know the data there myself
Okay.
for what remedies are, but certainly within the CCB, for example, it's been settlement before even talking about damages or injunctions. So oftentimes copyright infringement lawsuits won't go to trial. It will be settled beforehand, in which case we're talking about, damages and monetary accounting for.
Okay.
Yeah, again, a couple
Yeah.
thank yous, and thank you so much for your participation and wonderful questions and for having the Copyright Office. And Caroline, do you have any final remarks for us?
No, just thanks everyone for hopping on today. And again, thank you to Jessica and Sally and the U.S. Copyright Office for bringing this information to us. I think it was great to have you all today and definitely appreciate your time being here.
Yes, thank you. Everyone have a great day.